Hello everyone, my name is Deepto Roy and I'm a partner with the Projects and Infrastructure practice of Shardul Amarchand Mangaldas. I'm going to look at the impact of the COVID-19 crisis on long-term infrastructure contracts and in particular the force majeure clauses in these contracts. In an effort to combat the threat of the 2019 novel coronavirus outbreak, countries across the world have instituted stringent policy measures. As crucial as such policy measures are in curtailing the rampant spread of this virus, the nature and severity of these measures have caused considerable commercial disruption to operation of companies both inside and outside of India. On 11th March 2020, the Government of India, in exercise of powers under India's Disaster Management Act of 2005, advised all state governments to enforce measures relating to isolation and quarantine. The government thereafter invoked powers under the Epidemic Diseases Act of 1897 and the Indian Penal Code of 1860, and on March 24, 2020, imposed a total lockdown over the entire country, requiring all citizens to stay at home and stopping all movements of goods and traffic. Only essential services and supplies have been allowed as exemptions to this lockdown. While the lockdown was initially imposed for 21 days, it has now been extended to the end of April, and it is likely that further extensions will be considered, and in any event, restrictions of various severities will continue for a far longer period. Infrastructure projects, being primarily dependent on government interaction, movement of people and goods, and provision of critical services, have been impacted massively by the COVID-19 outbreak and the consequent lockdown. Most ports and airports are closed, road traffic is severely disrupted, construction activities have ceased outright, and power demand has fallen by more than 20%. The impact on supply and value chains will be significant and long-lasting. At the same time, several infrastructure players have had to continue operations under extremely challenging circumstances with skeletal staff and with severe difficulties in operations to keep critical infrastructure operative. In these trying circumstances, force majeure clauses in long-term infrastructure contracts can form an effective legal strategy in mitigating some of the financial and other losses. Most infrastructure contracts, being long-term contracts, incorporate force majeure clauses. Force majeure clauses outline circumstances typically beyond the control of the parties to the contract, which result in the affected party being excused from performance of certain obligations under the contract. First, we would come to the force majeure clause in the concession agreement of the National Highways Authority of India, the nodal agency responsible for the management of national highways. From the perspective of operators managing toll roads, the lockdown has impacted toll collection and performance of certain obligations under the construction agreement, including maintenance of the project highway. The Ministry of Road Transport and Highways of the Government of India has now advised the National Highways Authority of India to follow lockdown orders in relation to toll plaza operations, meaning that all toll operations are now suspended. The concession agreements stipulate force majeure clauses to cover events which a. are beyond the reasonable control of the parties to the concession agreement, b. the affected party has been unable to overcome the same despite exercise of due diligence and reasonable care, and c. the event has a material adverse effect on the project. Force majeure events are usually divided in the concession agreements into political force majeure arising out of government actions and non-political force majeure. The present situation, that is the COVID-19 crisis and the subsequent lockdown, can fall under both heads. A successful claim for force majeure under the concession agreement can result in either financial compensation or an extension of the concession period for the affected party, and in case of a prolonged event can also give the affected party a right to terminate the concession agreement. It is noteworthy that concession agreements for other sectors, including ports and airports, are similarly constructed and have similar protections. We now come to the FIDIC form of EPC contracts. The FIDIC standard forms of engineering, procurement, and construction contracts or EPC contracts include provisions relating to the occurrence of force majeure events, which are defined in these contracts as exceptional events. In the recently published editions of the FIDIC standard forms, including the Red Book and the Silver Book, a list of indicative events has been specified as extraordinary events. This includes war, natural catastrophes, rebellions, riots, etc. Any exceptional event which fulfills the aforementioned criteria would qualify as a force majeure. The affected party is excused from its obligations other than payment obligations, and if the contractor is the affected party, the contractor is further entitled to an extension of time and payment of costs for the works affected by force majeure. We will now look at the renewable power projects, and in particular the Model Power Purchase Agreement or PPA of the Ministry of Power and the Solar Energy Corporation of India Limited. These PPAs classify force majeure as natural, political, and non-political. Under the PPA, due to an event of force majeure, an affected party becomes entitled for extension of time to fulfill its obligations, and in certain circumstances is entitled to deemed capacity charges. Project finance documents entered into between lenders and project developers are typically drafted to ensure the right of repayment of the lender. Typically, these project finance documents do not provide any protection to the project developer for force majeure events affecting the developer. Financing documents do, however, contain provisions which state that an event causing a material adverse effect on the project would amount to a default under the loan agreement and lead to an acceleration of repayment obligations of the borrower. Similarly, occurrence of a force majeure event under a material contract of the borrower, for example a supply contract, a power purchase agreement, or an EPC contract, are sometimes designated as specific events of default under the project finance documents. It must also be kept in mind that most force majeure events will also trigger an information covenant to inform the lenders under project financing documents. It is here that regulators may provide some breathing space to the stakeholders. Example, the Reserve Bank of India has allowed banks to provide borrowers a moratorium for all payments due till May 31st, 2020. Similarly, insolvency norms have been relaxed so that financial difficulties caused by the COVID crisis does not result in a spate of bankruptcies. The general approach of the Government of India has been proactive and seems to recognize the COVID-19 crisis as an event of force majeure. As early as 19 February 2020, the Ministry of Finance of the Government of India issued a notification to clarify that with respect to the force majeure clause of the Manual of Procurement of Goods 2017, COVID-19 would be considered a force majeure event since it would fall within the definition of a natural calamity. A natural calamity is considered a force majeure event under the Manual of Procurement of Goods of 2017. On 20th March 2020, the Ministry of New and Renewable Energy of the Government of India directed that delay on account of disruption of the supply chains due to the spread of the COVID-19 in China or any other country should be considered as force majeure under the power purchase agreements of the solar projects. The MNRE also directed that suitable extension of time should be granted to projects which have been affected by COVID-19. State renewable energy departments were also requested to apply a similar approach to the timelines under their PPAs. The Union Road Transport and Highways Ministry has also advised the NHAI that the COVID-19 related situation should be treated as a force majeure under its concession agreements. Companies and institutions are going through challenging times, and they should be aware of the protection afforded by force majeure clauses with respect to their contractual obligations. As we speak, several industries and sectors have invoked force majeure under their contracts, and it is expected that claims of this nature will continue to increase. Certain specific action points should be kept in mind which would help in mounting a successful claim of force majeure. 1. Track disruptions. Monitor and document these disruptions in the project area, particularly supply chain disruptions, labor impact, and governmental actions. Maintain records of all written instructions and correspondence from government and law enforcement authorities. Keep detailed records of the impact of the disruptions. For example, the number of days of construction delay or the amount of toll losses. Conduct a detailed review of all material agreements that may be affected by the COVID-19 outbreak. Identify key provisions of material agreements that are impacted by the outbreak. This may include force majeure and MAC clauses, change in law clauses, dispute resolution provisions, representations and warranties, and other covenants. Evaluate whether there are any notice requirements, that is, whether there are any time limits specified in the agreements within which a notice of force majeure has to be provided. Also evaluate what rights, such as suspension or termination rights, under the material agreements are triggered by the force majeure clause. Plan proactive steps to mitigate the effects of force majeure. Evaluate if there are alternate means to meet contractual obligations and maintain a record of all steps taken in this respect. And finally, seek legal counsel regarding treatment of contractual issues arising as a result of the COVID-19 crisis. Thank you very much for your time.